when we interpret what a particular provision means today, don't we have to look at the entire, all of the relevant provisions that are in place at the present time?
Yes, Your Honor, and I think it's very telling that in the 30-plus years since J was written—
In other words, we have to, we have to assume that it's all meant to fit together somehow, right?
I think it's fair to look at the passage of time, Your Honor, and I think that works in our favor. Because there's no suggestion by anyone here that in 1994, Congress wanted someone sentenced to death to get 5 years on top. It may seem odd now that 5 is a floor rather than a fixed term, but Congress has had 31 years, Your Honor, to address this problem if it is a problem. Congress has decided it's not a problem. And why? Because J is enough on its own to punish someone who lethally uses a gun.
Do you think that a clear congressional desire to provide multiple punishments for a greater and lesser included offense can be inferred from the penalty scheme?
Well, I think—
Can it ever be inferred from the penalty scheme?
So the penalty, Your Honor says the penalty scheme. So every statute has a penalty.
Suppose that the the maximum penalty for the greater offense, in the sense that it includes more elements, is 1 year, but the maximum penalty for the lesser included offense, in that it has fewer elements, is 2 years. Do you think it would be that a clear congressional desire to have multiple punishments in that situation could be inferred?
No, Your Honor, and there is a case that we found after briefing by Judge Posner. It's U.S. v. Peel, P-E-E-L, 7th Circuit, 2010. There, the judge explained the lesser included offense was obstruction of justice with a 20-year maximum. The greater offense in that case was bankruptcy fraud, which has a 5-year max. So it's exactly the scenario that Your Honor has just posited, this weird situation where the greater offense actually has a lower penalty. Judge Posner says, same offense, no clear indication to double punish. I'm sending it back for one conviction to be vacated.
Well, are we bound by that decision?
No, but I think it's a good example.
Why does it make sense?
I think it makes sense.
Why does it make sense?
I think it makes sense, Your Honor, because it's entirely in line with this court's consistent jurisprudence that because courts don't decide punishments, it's Congress that does so. Courts have to be very careful before they decide that Congress wanted to pile on and double punish one crime. It needs a clear indication. And the fact that 2 different statutes may require punishment, may require even minimum punishments, or even have clauses saying, notwithstanding any other provision of law, don't suspend the sentence. I'm describing now the scenarios in Rutledge. This court said that is not enough to be a clear indication to double punish. There must be more, and here there is no more.
Thank you, counsel.